After 17 long months of incarceration, Delhi's former Deputy Chief Minister Manish Sisodia will finally walk out of Tihar jail, who was arrested by the CBI and the Enforcement Directorate in connection with the excise policy scam. The Supreme Court today granted Manish Sisodia bail on two grounds. The court said, firstly, we have to see that he's been held in jail for the last 17 months, which constitutes a long period of incarceration. Secondly, there is no likelihood that the trial against him would be completed in near future. So the Supreme Court says that if we were to look purely from the prism of the right of a speedy trial of an accused, Manish Sisodia is entitled to bail. The court also said that in this particular case of excise policy, which has been lodged against him by the CBI and the Enforcement Directorate, there are 493 witnesses, over 1 lakh documents which will have to be examined by the trial court. And if you look into the time period which will be taken by the trial court to examine these documents, it does not look like that it could be completed in near future. One very interesting thing that the court said while granting bail to Manish Sisodia was that it seems that the trial courts and high courts have forgotten the cardinal principle with relation to bail, and said that even the trial courts and high courts have to realize that bail is the rule and jail is an exception. Justice Gawai, who pronounced the verdict in open court, said that the trial courts and high courts have forgotten this cardinal principle, and as a consequence of which, a lot of bail appeals are finally coming to the Supreme Court, which the Supreme Court judges have to decide, and that is also clogging the system in the Supreme Court of India. So the Supreme Court has reminded the trial court and the high courts that, look, even in the most heinous of the cases, even if it were to be a UAPA case where the accused is a terror accused, bail cannot be denied to him, because his right to get bail has to be balanced also with his right to speedy trial. And the right to speedy trial is a facet of Article 21 of the right to life. So in totality, while the courts adjudicate on bail matters, they should keep in mind that bail is the rule and jail is the exception. Second, the right to speedy trial is a fundamental right, and it should only be denied to an accused in exceptional circumstances. Now, in this particular case of PMLA, what you have to see or keep in mind is the fact that the government and the Enforcement Directorate authorities have been arguing before the Supreme Court that under Section 45 of the PMLA, they have to be heard first, and without they being heard, no bail can be granted. So today, the Supreme Court has said that agreed that the prosecution has to be heard, but that does not become a ground to deny bail to the accused, because in this particular case, the accused has suffered a long period of incarceration, and secondly, there is no likelihood that the trial against him would be concluded in any time in near future. So his right for speedy trial, which is a part of a right to life and a fundamental right, is affected. So on these grounds, the accused Manish Sisodia is entitled to be released on bail.